Hello, I'm Andy Agathangelo, the founder of the Transparency Task Force. The Transparency Task Force, or TTF, is a certified social enterprise. We are battling to help promote the idea that the financial sector should be more transparent, more truthful, and more trustworthy. And it really is a battle. You would be amazed, ladies and gentlemen, how much of an opposition there is to the idea that the financial sector should be transparent, truthful, and trustworthy. More and more of our work is about challenging the way that various institutions work. We are particularly disappointed, speaking frankly with you, with the performance of the Financial Conduct Authority in relation to its consumer protection remit. And what we've noticed over the years is that it's becoming increasingly challenging to get the truth out there. And of course, one of the reasons for that now is to do with SLAPPS, this issue we're going to be focusing our attention on today. We have a great lineup of speakers. We're going to be going shortly to Roger Muller, who's going to be setting the scene nicely for us. Roger is a very, very popular former MP, a wonderful supporter of the work of the Transparency Task Force. I'm very, very proud to say that Roger's actually on TTF's advisory group, and believe you me, he gave us such wise counsel. It's great to have Roger with us. But we'll be hearing from other people as well. In fact, Joanna Cherry MP is going to be chipping with a few thoughts as well after Roger has spoken. So I do hope that sets the scene quite nicely. I want to turn all of your attention, if I may, to a quotation that I refer to quite frequently. I'm going to share my screen to make sure I do this justice. And it's a quotation from Robert F. Kennedy. And it's about this idea. It's on the webpage for the event that we've created today. It's one of my favorite all-time quotes. It really does chime with the work of the Transparency Task Force. And as you can see, what it says is, every time we turn our head the other way, when we see the law flouted, when we tolerate what we know to be wrong, when we close our eyes and ears to the corrupt because we are too busy or too frightened, when we fail to speak up and speak out, we strike a blow against freedom and decency and justice. I think it's virtually impossible, ladies and gentlemen, to think of a better set of words to talk about the very reason the Transparency Task Force exists. We have a community that's made up of 100 or 200 active participants, plus several thousand people around the world in 21 countries who receive our weekly newsletter. We are becoming increasingly concerned about the failure of the system as a whole to do what it is meant to do. And in all honesty, I personally am becoming increasingly concerned about something we spoke at one of our previous events to do with state capture, where there is systemic failure of the system to operate as it is intended. This is a real worry. One of our speakers tonight is Paul Carlier, a man I have the pleasure of interacting with a great deal. Paul is like a one-man army campaigning for change in this financial sector. Paul and I were speaking earlier today about the sorts of issues we're going to be talking about tonight. And I can honestly promise you that Paul and I had a conversation earlier today about the widespread collapse of the integrity of the system. And I know I'm starting to sound like my dad, and I know I'm starting to sound a little bit like a conspiracy theorist. But in all honesty, when you witness what we have been witnessing, when you see what we have been seeing, when you, for example, read the testimony of people that have been talking about the Financial Conduct Authority, when you hear from politicians about what some of their constituents are experiencing, you come to a very simple decision point. Do you stand by and let it all happen? Or do you stand up? And I've dedicated the rest of my working career to the idea that it's worth standing up. It's worth having a go. It's worth fighting back. Even if you don't win, have the damn fight anyway for those that come after you. The better the job we do of standing up for right today, the less of a job our kids, grandkids will have to do in the future. And I'm dead serious about this. I'm absolutely dead serious that we need to fight for things that once upon a time, we kind of took for granted. There is a lot at stake here. There really is a lot at stake here. I'm going to share my screen once again. I normally wouldn't do it, but I really do want everybody to understand the importance of the topic we're talking about tonight, because sometimes there's a tendency for things to be a bit of a thin end of a wedge. And to my mind, I've got massive concern about SLAPPS because they have the potential to become the thin end of a wedge. Robert F. Kennedy. After I finish this quotation, we'll pass to Roger. Every time we turn our head the other way, when we see the law flouted, when we tolerate what we know to be wrong, when we close our eyes and ears to the corrupt because we are too busy or too frightened, when we fail to speak up and speak out, we strike a blow against freedom and decency and justice. And I admire, and I continue to admire, and I will continue to admire everybody that stands up rather than stands by. And one of those people is somebody I've had the pleasure to get to know a little bit over the last year and a half or so, Roger Mullen, who's going to share his thoughts on the importance of fighting against SLAPPS and what can be done through Parliament to try to bring about the kind of changes we all want to see. Can I please invite you to put your hands together to thank Roger for setting aside some time to talk tonight and for sharing his tremendous expertise on this topic. Roger, over to you, sir. And when you're ready for me to share your slides, please do so. Thanks, Roger.
Yes, well, thanks very much for the introduction, Andy. I don't know if I deserve it. And I would like to thank the audience for the applause beforehand, which means that you don't need to worry about being oppressed into clapping after I've finished. Let me start by saying a few words about my own background. I was an MP from 2015 to 2017, during which time I became heavily concerned about corruption in the financial sector. And in particular, one of the issues I pursued was what's known as Scottish limited partnerships and the way in which they were the front for a tremendous amount of corrupt activity, some of which continues to this day. So I come from a background of interest in that. But I'm like any ordinary person in society at times. I'm interested in looking at crime and criminal behavior and watching programs and watching films. And that's going to allow me to lead in by saying the following remarks about investigative journalism, because my opening remarks are, I thought of this evening based on a film about the journalist Veronica Guerin in Ireland. And investigative journalists like Veronica are at times assassinated, murdered for attempting to expose corruption and criminality. Veronica was assassinated by organised crime in Ireland in 1996. More recently, the investigative journalist Daphne Galizia in Malta was assassinated in 2017 because she fought against corruption in Malta, both in economic and in the political world. And it was largely the assassination of Daphne that ignited the rise of people wanting to campaign around these issues of SLAPPS. I think, although we can all identify with the horrors of the gun in trying to silence investigative journalists, researchers, and others, people over time who want to protect the corrupt have found another weapon. They have found a weapon not of the gun, but of their abuse of the law to try and silence people who want to reveal matters that are in the public interest. Could you share my first slide, please? Now, part of the problem is that in some jurisdictions, Scotland is one, there is no very clear legal definition of what SLAPPS are. So I'm speaking here, well, neither as a journalist nor as a legal expert. So I'm glad that Joanna's here to follow me. So my common sense understanding of what SLAPPS are is that they're abusive legal claims intended to prevent publication of information that is in the public interest. The victims of SLAPPS most notably include investigative journalists, academic researchers, and campaigners. But I would argue society as a whole is also a victim. It's a victim in any democratic society where individuals are prevented from getting access to information about people who are acting corruptly and against the wider interests of society. They have become, SLAPPS, the weapon of choice for very rich individuals, oligarchs and the like, and in some cases corporations, who can hire expensive legal firms, so-called reputation management firms and others, willing to take the lucrative fees and offer to close down publication of information that is in the public interest. A few years back, one day I was sitting in a car park in Fife and I received a call. And I received this call about a day or 2 days after I had been called by a newspaper, largely because of my previous activity about SLPs. This wasn't about SLPs, but it was about corruption in the financial sector. And they told me about it and asked if I would give a quote, which I gave a quote to the newspaper and thought little more of it until I received this call. And this call was from a so-called reputation management firm in London. And basically, the newspaper had gone to them and said, we're going to run this story. We've got this quote from Roger Millen and no doubt many others. Would you like to comment on the story? Well, they didn't want to comment on the story, but what they did do, or what was done, was they then started contacting people like myself. And in a very polite manner, pointed out that the person who was the subject of this story was a billionaire, and he could ruin everybody involved in this story by taking legal action, and he wouldn't even need to win. Because the cost of this type of action, private prosecutions and the like, meant it would have been far too much to defend. And understandably, what happened was it never progressed. The newspaper said, we can't run this story because we could never get involved in the costs of defending an action. And so this was just one small example of a story which was shut down merely by the threat of legal action. Now, what is the goal, therefore, of a SLAPP? It's to put its target, mainly, I mean, not myself, but investigative journalists, for example, through such financial and emotional strain that it prevents publication, even where the information is accurate, important, and in the public interest to share. They don't have a right to share. And in my humble opinion, this is an example where, although many people talk about the importance of freedom of speech, we need to do an awful lot more in our society to enable effective freedom of speech in areas that are in particularly the public interest. Could I have the second slide, please, Andy? Therefore, and many, and I've said here, probably most SLAPPS never reach a court. So we don't know how many of these types of abusive legal threats are around in any jurisdiction. There is some information that suggests the UK is particularly open to and prone to SLAPP actions. But the main point I would like to make is SLAPPS therefore have a chilling effect on freedom of expression, undermining a basic tenet of democracy. And they seek to use not one type of law. People have said, oh, this is all about defamation law. It's not. It's about a range of laws that at different times are used to threaten their targets. They might seek to use threats under GDPR. I know of one example where I would call it a SLAPP-like action took place in Scotland, way back in 2009, involving a university that I'm closely associated with. And basically what happened there was that a firm in London sought to get access through freedom of information, asked for access to all of the research information held by the university in relation to tobacco research that was being undertaken. And they wanted access right down to, who contributed to the research, the people who were being interviewed and all the rest of it. And it was only after some time that it came to light that the person asking for this information was not the source of the request originally. They were a front for a very large multinational corporation who were getting them to do their bidding. And so that's an example where academics have been put under considerable strain with threats for action. Now, because of this, many campaigners now, in Europe in particular, believe there's a need for anti-SLAPP laws for a number of purposes, making it a lot easier to dismiss vexatious threats at an early stage, and to have those who raise such actions be liable in different ways, including for the costs, and basically to give greater protection to people like sort of legitimate investigative journalists, academic researchers, and the like. And I have been particularly concerned that although there have been moves to tighten up the law in relation to the law in England, there had been little moves, no moves, in fact, to do anything in Scotland. So about a year ago, I raised myself a petition. And it's now going through the process. There is a second meeting of the Petitions Committee to consider it in a couple of weeks' time. There are lots more people in recent times getting involved in this. There is a specialist unit at Aberdeen University who have been researching into SLAPPS. I attended a workshop fairly recently that they kindly invited to me at, and they're going to set about trying to construct a model law for Scotland in relation to SLAPPS. So there's a lot of work to be done, but I personally believe that this is a major threat to effective democracy. It's a major threat to trying to create a society that can be, in Andy's words, more transparent and more concerned to share the truth about what is going on in society. And I'll just leave it there. I think I've said enough. Thank you very much.
Yes, thank you very much indeed. You've set the scene so nicely for us. In a moment, folks, we're going to open up for any questions or comments in relation to what Roger has just been speaking about. We're then going to hear from Joanna Cherry with any thought that Joanna would like to share. Joanna Cherry MP, I should say. What we're then going to do, Matty, if it's okay with you, we're then going to go to Emma, and then we're going to go to Matty. We're just changing things around for you, Emma, if that's okay. And then we'll be going to Paul Carlier. And throughout the whole process, we'll try and open things up for Q&A and make this as conversational as possible. So with that in mind, would anybody like to come in at this point with any comments or questions feeding off the back of what Roger's so far been speaking about? Please do raise your hand either digitally if you know how to, or literally wave at me if you want to come in. If there isn't anybody at this point, I'll just ask Roger a quick question myself, and then we'll go straight to Joanna. Okay, I'm going to raise my question. So, Roger, it's very interesting that in my personal experience of SLAP type activity, the other party, the slapper, for want of a better phrase, that might not be a very good phrase, has basically, they don't even need to sort of directly threaten you. They just do it in a kind of indirect way. For example, I'll share this in a bit more detail later. We the TTF were doing something to expose some stuff going on to do with a business banking resolution service. And I got an email from somebody from the business banking resolution service that basically said, yada, 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 yada. And may I remind you that if you say anything at your event that may not be, provable, there are laws in place to deal with defamation, etc., etc. So they can be quite kind of indirect and not so in your face, but you know that they are actually trying to scare you without actually saying, "I'm trying to scare you." And that, to my mind, makes it even more insidious in some ways. Any thoughts about that, Roger?
Yes, well, I'll go back to the example I gave, because that's exactly what I felt when I received the call from a reputation management firm. And basically, the person at the end of the phone, I have to say, was utterly charming. And indeed said, the next time you're in London, why don't we have a coffee? I'd really like to discuss lots of the good things you've been doing, Roger. Yeah. But you should know that this person I'm speaking to you about is, is very angry about the things that are going to be said about him in the newspaper, and wants to make sure that people understand he is, as the reputation management firm said to me, this is a billionaire. He's got plenty of money to be able to pursue this using the law. Now, it was all done very charmingly, but when I went back to the newspaper who'd had a similar call, we all knew what was being said, right? And to me, that was that is from what I have heard from others, that's a not untypical approach. I mean, they wouldn't be as crude as to say, stop this or all hell is going to fall down upon you. They do it in sleekit ways, as we might say in Scotland, just as you've described, Andy.
Roger, thank you very much indeed. Folks, can we do two things simultaneously? We'll applaud Roger for his sharing of his thoughts so far, at the same time welcoming Joanna to the microphone, so to speak. Thank you very much, Roger. And Joanna, when you're ready, over to you, please, to share your thoughts. Thank you very, very much indeed, Joanna, for being here. Thank you.
Thank you, Andy, and thanks for inviting me to join you. I'm not going to speak for long because I know that others were down to speak and I only acknowledged at short notice. For those who don't know me, I'm the Member of Parliament for Edinburgh South West, and my interest in this really arises from the fact I'm a lawyer, although I'm by no means an expert on SLAPPS, but primarily my interest arises from my membership of Parliament's Joint Committee on Human Rights, That's a cross-party committee of both houses. We carry out scrutiny of government legislation and policy for human rights compliance, and we look particularly at compliance with the European Convention on Human Rights. So I'm going to concentrate on human rights aspects of the debate about reform. Last year, the committee had a one-off evidence session on SLAPPS to try and understand the nature of them, the nature of the government's plans for reform, and very much to focus on the human rights issues that arise. And you can read the transcript of that evidence session on our website. We had a couple of lawyers with expertise in this area, and we had Nick Williams from Index on Censorship and a writer called Oliver Bulow, who some of you may know, who's been the victim of SLAPPS. Suffice to say that all of them were in favour of reform of the law, apart from one of the barristers who was sceptical about the need for legislative change. Basically, there's three human rights that SLAPPS engage. First of all, and Roger mentioned this already, and I should say what a pleasure it is to join Roger, my former colleague and fellow party member, on this call, and applaud Roger for the work he's done in this and other areas. But SLAPPS basically engage Article 10, which is the right to freedom of expression. They also engage Article 8, which relates to privacy. And that's a bit of a problem for those of us who want to reform the law here. Reputational protection is becoming quite a big thing in European law, as well as the respect for private life. And there's also a risk that anti-SLAPP reforms could interfere with people's rights under Article 6. That's the right to a fair trial. And when we're talking about civil obligations, as we largely are here, everyone has the right to the determination of their civil rights or obligations and entitled to a fair and public hearing. So there is a bit of a tension between the right to freedom of expression, the right to privacy, and also the right to a fair hearing. But I think this tension should not preclude us from looking at reform. And I just want to say a couple of words about what the issues are and what the tensions are. Article 10, the right to freedom of expression, is a qualified right. That means it can be interfered with if it's justified, prescribed by law, and necessary in a democratic society. However, we do put quite a high value on freedom of expression in Europe and indeed in the United Kingdom. The Strasbourg court has held that unreasonably high damages for defamation claims can have a chilling effect on freedom of expression. And under the Human Rights Act, we have a Section 12, which emphasises that the courts must pay due regard to Article 10 and the right to freedom of expression. SLAPPS represent a serious threat to freedom of expression. And if you look at the evidence we took, I think Oliver Bulow in particular spoke very powerfully about the chilling effect, the fact that an email, a threatening call, etc., can be quite off-putting. And also journalists working in a particular field may come to the conclusion that they wouldn't even touch a particular person or even start investigating a particular person because they know that there might be, that they might come after them in defence of their right to privacy. Article 8 of the ECHR provides that everyone's got the right to respect for their private and family life and their home and their correspondence. But like Article 10, that's also a qualified right, meaning that it can be interfered with if it's justified in accordance with the law and necessary in a democratic society. There is some case law about how we balance freedom of expression and privacy. And a very distinguished English judge said in a well-known case, I'm talking about Lord Hoffman, that both Articles 10 and Article 8 reflect important civilized values, but sometimes neither can be given in effect in full measure without restricting the other. He asked how are they to be reconciled in a particular case, and he said there was no question of automatic priority, nor is there a presumption in favour of one rather than the other. the question always really turns on the circumstances of the case, which isn't particularly helpful, I have to say. There's clearly disagreement amongst people in this area about whether UK law strikes the correct balance between Article 10 and Article 8. Those who want reform of the law in order to address SLAPPS say the balance is too much in favour of Article 8. Others think the balance is about right. So those are the sort of issues that reform would have to engage with. I'm not so much across the detail of what's happening in Scotland, because I'm more focused on what's happening in the UK. And of course, we had an announcement from the government last week. But clearly, if the government bring forward legislation, then the committee I sit on is going to play an important role in scrutinising its human rights compliance. And again, thanks for listening to me.
Joanna, thank you very, very much indeed. Our next speaker, Emma, does work that relates very closely to what you're doing on the human rights front, Joanna. It's a very fortuitous similarity in the territory that you've just been covering, which is great. Would anybody like to come in? Please raise your hand, either literally or digitally, if you wish to come in at this point with a comment or a question before we go to Emma. It looks like everyone's okay. In which case, can we do the same, please? Can we both thank Joanna for sharing her thoughts as we welcome Emma to the microphone? Thank you very much indeed, Joanna. Great stuff. And Emma, please take an opportunity, first of all, to introduce yourself, tell everybody where you are, and tell everybody a bit about what your wonderful, wonderful organisation is and does. And then, of course, move into telling everybody your thoughts about this hyper important issue around SLAPPS. Over to you. Thank you.
Thank you so much, Andy, for inviting me. My name is Emma Bergmans. I work as a senior policy and advocacy advisor at Free Press Unlimited, which is an international press freedom organization headquartered in Amsterdam, but working globally. And our mission is to make independent and reliable news available to everyone around the world, which is why we especially work in countries with shrinking civil spaces. I just wanted to sketch a bit of a picture of what the situation looks like globally. I think over the past few years, we've seen an alarming increase in the attacks of journalists around the world. Every day, journalists are attacked, they're harassed, they're intimidated just for doing their work, especially if they expose wrongdoings or hold powers to account. Increasingly, we also see that judicial harassment is being used. Prosecutions, long-running lawsuits, and imprisonment are a few of the strategies that are employed by state and non-state actors to silence journalists. And we see that this trend is increasing year over year. In the annual roundup of Reporters Without Borders, another international press freedom organization, a record total of 533 journalists were imprisoned at the end of 2022, which is a significant jump from 2021. So we really see that this is increasing year after year. And unfortunately, when we think of safety of journalists, we often think about, for example, conflict countries, journalists working in Ukraine, working in Myanmar, working in Sudan. But we see that their safety is not only deteriorating in those countries, but also in democracies around the world. Especially investigative journalists have increasingly come under pressure. And governments and other non-state actors have found innovative ways to silence them through vexatious lawsuits, and especially SLAPPS are on the rise. As Free Press Unlimited, we're part of a coalition called the Coalition Against SLAPPS in Europe, also called CASE, which investigates yearly the number of SLAPPS that there are in Europe and advocates against them. And in 2023, the SLAPP database by CASE jumped to 820 cases. Before it was 570 cases in 2022. So that's quite a big increase. And a notable number of these are mapped in Malta, France, Croatia, Greece, Turkey, Georgia, and the United Kingdom. By the end of 2022, the majority of those cases were civil lawsuits, but also almost 21% were criminal lawsuits, often in relation to defamation legislation or similar insults of honor, for example. And the majority of those cases are filed by businesses or business owners, followed by state-owned entities and politicians. As we all know, I think we're all here, the main category of SLAPP defenders are unfortunately journalists, personally often, not their media organization, but journalists on an individual name. We also see this trend back in our own data. Free Press Unlimited has an emergency program which is called Reporters Respond, through which we support journalists at risk and journalists in distress. Since 2018, we've supported over 950 journalists that were facing legal harassments. And in the majority of those requests, they're facing criminal prosecution, terrorist groups disrupting public order, or engaging in cybercrimes. And through this support, we help them to gain legal representation, for example, or even to get them released conditionally. In addition to providing this practical support, we also actively advocate for better legislation against legal harassment. And I just wanted to update you a little bit on what's happening at the EU level, because currently there's a draft proposal for an anti-SLAPP directive on the table. And although the position of the European Commission and the European Parliament is quite positive, the position of the Council of Member States is very disappointing. They've watered down several key provisions of the earlier position, which really waters down the protection for victims of SLAPPS. Contrary to the European Commission and the European Parliament, the Council only considers a case to be cross-border when the claimant and the defendant are not domiciled in the same country. And this is a huge issue because we see that in the majority of SLAPPS, people are in 90% of those cases, the claimant and the defendant are actually living in the same country, but the case does have cross-border relevance. So I'm also thinking about the case of Daphne Caruana Galizia, for example, who was, of course, investigating such enormous issues that had a relevance not just on Europe, but actually worldwide. And this would not fall under the mandate of the directive. And I think one of the major issues also with the position of the Council is that it has included a very restrictive definition of what is actually a SLAPP, what is a manifestly unfounded case. At the moment, they argue that it has to be without any reasonable doubt, without scope for any reasonable doubt, which is such a high threshold to meet that almost no SLAPP would even fall under this directive. And one other concerning thing that Roger already touched upon is that the provisions regarding damage claims have been completely removed, meaning that SLAPP victims wouldn't have access to damage compensation, but also to payment of their legal representation, for example. And given the enormous financial, but also psychological impact that SLAPPs have, this is incredibly concerning. So together with the Case Coalition, we're trying to advocate to make sure that during the negotiations that are currently taking place between these three parties, the European Commission, the Parliament and the Council, some of these key provisions are not watered down. Unfortunately, it's a difficult battle to fight. We see that there's a lot of resistance within member states to make sure that this directive is really strong for the victims of SLAPPs. And we unfortunately see that it is painfully apparent that a free press can never be taken for granted, even when democratic rule has been in place for decades. So we continue to advocate for strong legislation and try to support journalists wherever we can. So I'm really excited to see these efforts and for people to come together and work jointly on this topic. Thank you so much.
Emma, thank you so much. That's wonderful. Absolutely wonderful subject matter expertise that you've shared with us today. Emma, I have to ask you this question. So the watering down of the protections that you've just spoken about, the attempted watering down of those protections, who are the opponents here? Who is trying to water down the protections for society? Where's the lobbying coming from, you know?
I can't say for certain, but one of the arguments that keeps being used by member states is that they often say that they want to protect access to justice. And one of the questions we keep asking is access to justice for who? Okay. Because at the moment, it is not access to justice for SLAPP victims. It's access to justice for those that initiate SLAPPs, which are often wealthy business owners, which are often state-owned entities, which are often even politicians themselves. I've actually written an opinion article together with the sister of Daphne Caruana Galizia, which I can share with you, in which we talk about this a bit more. Because every time we try to address this with member states, this is the argument that we get. We need to make sure that access to justice remains guaranteed.
Thank you. Please do share that, Emma, and anything else, because we'll be circulating the notes after the meeting, probably sometime tomorrow. Please do share that. Does anybody else want to come in with any comments or questions for Emma? Again, just wave your hand literally or digitally We're going to go to Mr. Paul Carlier, but I mentioned Paul earlier. Some of you won't know Paul. I think more and more about Paul being a one-man army when it comes to campaigning for reform of the financial system. Paul is one of the most respected and admired campaigners within the Transparency Task Force. And you would not believe how many fronts Paul is battling on. And the unifying theme in all of Paul's work is just access to proof and justice. That's what the man's all about. Paul Carlier, please share your thought. Thank you.
Yeah, I'd like to thank all the speakers so far and Emma as well, and raise the what Emma's saying. Everyone has to be worried, right? We're talking about we live, World War II and the fascism and the despotic states that we're supposed to have left all this way behind. But from what Emma's talking and what my own personal experience and that of others, does it not? Is Emma as concerned as I am that this represents a worrying trend, that we should be feeling much safer and much more protected by what we regard as a democratic process than we actually are?
Just to comment on that, incredibly worried, Paul. I'm incredibly worried. And especially, I think what I'm especially worried about is the response that we get. Every time we try to bring up these issues with our own member states, and this is across case, it's not just Free Press Unlimited, but I think organizations within the coalition trying to discuss the problems that we see and how it wouldn't protect journalists and how it wouldn't protect SLAPP victims. It's like we're talking against a wall. And that really concerns me, that there seems to be no room to discuss what's at stake here and what the effect can be, not just on journalists, but for democracy at large.
Which takes us straight back to that quote from Robert F. Kennedy from all those years ago. We really do have to. It's sad to say it, folks, but here we are in 2023. Having to fight for freedoms and rights that, in all honesty, I completely took for granted as I was growing up. And I don't know about you folks, but things seem to be turning a rather ugly corner.
I may add,
go on, Paul.
Andy, you were present on Friday at a case management hearing for a case I'm bringing to the first tier tribunal on freedom of information requests. I will summarise very briefly, but basically, the FCA annual public meeting last year, the FCA made 7 false and or misleading representations about the Blackmore Bond case, which is very close to my heart, was featured in Panorama last year. And I sent in 7 freedom of information requests. Each one quoted from the transcript something that the FCA had said. And I attached and enclosed documentary evidence and quoted the extracts from it that challenged or contradicted what the FCA had said. And asked the FCA in each, please provide information to explain the disparity or inconsistency between what you've said and the evidential documentary record that I've enclosed here. The FCA refused to provide the information on the basis that they were vexatious. The quantum of them, I'd made too many, and are fighting this all the way to the first tier tribunal. And they've actually said that my purpose was or intent was not to obtain information, but it was to embarrass the FCA and to harass and cause distress to FCA staff. I mean, it's extraordinary. I mean, the bottom line is the quantum is proportionate to the number of times you lied. The Freedom of Information Act exists to hold public bodies and public people accountable for everything they say or do. So the quantum is, the defense is, if you're going to lie repeatedly, so you can then use the quantum of the request as a reason to deny it. Now, we go back to and the point about investigative journalism. I mean, it's like Richard Nixon saying, refusing to disclose information on Watergate because poor Woodward and Bernstein had upset him a little bit. It was harassment of him. When if you lie, it can't be harassment if somebody seeks to hold you accountable to it. I mean, Andy, you saw firsthand on Friday how the FCA was trying to defend this. It's extraordinary, but it goes to, again, freedom of speech and democratic process.
Thank you, Paul. I'm going to ask Joanna a question, if you don't mind me asking this to you, Joanna. Presumably, the issue of SLAPPS is a pretty non-party political issue. Is there scope to get real support in Parliament for the kind of reforms that we think are necessary, or are you finding that some parties are less enthusiastic about freedom of speech, etc., as others?
Well, I could talk about what people say about freedom of speech when it suits them and what they don't say when it doesn't suit them all evening, but I'm not going to go off on that particular topic. What I will say, the good news is that there is cross-party support. I'm not sure of the present position of the Conservative government, but I know there are Conservative backbenchers like David Davis who are very committed to reform in this area. And and I think there will be other Tory backbenchers, and I think you'll find support for it in all the other political parties. The question really is how much of a priority it is, and how the government go about reconciling these competing rights. And I really very much want to endorse what Emma said about access to justice. We hear a lot about access to justice, but those who can access justice the most readily are those with the deepest pockets. And, you know, I recently had to get involved in some litigation, and it settled out of court, but my pre-litigation costs were in the region of £25,000, just really for an independent KC's opinion and some letters and a couple of consultations. And most people just don't have that kind of money. I was fortunate enough to get assistance from someone with it, but most people just don't have. Most people don't have £5,000 to spare at the moment. £1,000 to spare, never mind that kind of money. So I think there is an awareness. One of the best things that could be done, of course, would be to extend legal aid, but that's not going to happen at the moment. Not in England and Wales for sure, and in fairness, not going to happen in Scotland either.
Thank you very much, Joanne. Thank you. You've probably noticed the note in the chat from Mate. He's had to bail out. Something's come up short notice. He's working and travelling abroad. So after any comments or questions now, we're going to go to Paul. Paul, you're good for time. You'll be pleased to know. You're good for time. So does anybody else want to come in before we go to Paul? Lord Strathcarron, please take a moment to introduce yourself, sir, and take the time to share your thoughts. Thank you very much, Ian. Thank you.
Yes, I just wanted to follow on from what Joanna was saying. My interest is I run the Free Speech Peers WhatsApp group, and I'm a member of the All-Party Parliamentary Group for Publishing and also another one for media. I'm just wondering if there's anybody who liaises on for transparency on parliamentary work, because I agree completely with Joanna. There are lots of individual people you talk to, I mean, in our parliamentary groups on publishing especially, who are very anti-SLAPPS. And we had a big anti-SLAPPS party about 6 months ago, but it's all just very uncoordinated. And if there was just a central person or even a WhatsApp group or just some way of reaching out to other people, I think it would be helpful. So really, I just wanted to ask if you have anyone doing parliamentary liaison.
What a great point to raise. Joanna, this is going to go back to you. Any thoughts on that? And then we'll go to Roger. He's also put his hand up. Thank you, Lord Strathcarron, for making that point. So thank you.
Just very quickly, I'm just checking whether there is actually an all-party parliamentary group on SLAPPS, because I've been to a few meetings in Parliament.
It's publishing. Sure. Yeah, it's the publishing group. They ran the party. Yeah, it's the publishing are the ones most involved.
Okay. So I don't know. I mean, I'm not really in favour of a huge proliferation of APPGs, but it might be better to have some informal WhatsApp. I certainly know in other areas where I'm working cross-party, what we tend to do is to have like a WhatsApp group and meet regularly. And that might be something we could talk about, Lord Strathcarron,
afterwards.
Next time I'm in Westminster.
Yeah.
Unfortunately, I'm in Edinburgh just now, but after the conference season, I'll be back down in Westminster. Yeah.
Okay, let's get together and try and set something up.
Thank you.
Excellent.
Thanks. Roger. Roger, your thoughts on this particular matter? Thank you.
Yes. My thought is, of course, the more that things can be coordinated and the more brains that are brought to the table, then the more likely it is we're going to be able to work out a strategy to make progress. Now, in November, the 28th and 29th in London, there is going to be a conference on SLAP, purely on SLAPPS and the way forward. Now, I don't have all the details to hand, but what I was going to suggest, Andy, is I will send you, might be tomorrow, the details of the conference, and you might circulate it to all those who are on this call, assuming that they're interested, because that might be a venue. I mean, I'm going to be one of the myriad of speakers at it, but it might be a venue where like-minded people, like people in this group, could come together if they're available.
What a wonderful practical idea. And thank you, Roger. Thank you, Joanna. And Lord Strathcarron, thank you for being here and for raising that point, because it looks like there's a real appetite for people to work collaboratively. Thank you, Lord Strathcarron. Would anybody else like to come in at this point before we go to Paul Carlier? We're going to be going to Paul in just a moment. Mr. Carlier, please, back to you to share your thoughts. And Paul, we're good for time, so you don't need to be as succinct as I sometimes ask you to be. Thank you.
Before I start, I just wanted to pick up on something that Joanna said. The access to justice is something that I find, increasingly concerning, and a lot of my work involves trying to get justice for people. Just to give you an example, in 2002, I had a trial again in a claim that I brought against Chase Manhattan, my former employer. It was 18 months process. My legal costs, including barrister, for the whole process was 24,000. Chase Manhattan's legal costs for the whole process was around 68,000. Now, I've done this. It's very rudimentary analysis, but I asked the same to my solicitor, what would that cost me today, and what would the cost of the other side be? And he said, bottom line, he said you wouldn't get any change out of 350,000 today for your costs, and their costs would be double that. And this claim was 35,000. So in 2001, when I bought the claim, there was an element of risk reward there. I had to stretch myself to afford it, and there was obviously a risk. But to take a claim now for 35,000 that would cost you 300,000 plus to is extraordinary. And he explained that it's not because lawyers' fees have necessarily gone up, but they have, because so many firms are being retained by the banks and large service. Their fees, they can charge astronomical fees because the banks have got the deepest pockets, as Joanna rightly said. But what they're also doing, and it does partly involve SLAPPS, is that there was probably during that 18-month trial, there was about 6 bits of back and forth between the sides. It's nowadays, he said, you'd be bombarded with communications, all of which we have to respond to on your behalf, all of which ramps up the costs and just makes it, basically just delays the process, makes it cost ineffective for anybody, and basically deprives anybody of any opportunity. Also, judicial review. I've got an application in process for judicial review against the FCA, ICO, and Complaint Commissioner. I got a quote from 2 law firms to run this for me. One was 250,000, the other was 300,000. This is a judicial review, right? This is where, if a public body's breached their statutory obligations, we can bring this. The actual cost of filing it yourself, as I've had to do myself, was £154. So so I'm having to proceed with it on my own without any sort of representation, because who can afford £250,000? It's just astonishing. So I just wanted to make that point before I start my presentation, if that's all right. Right. Okay. I'm going to try and share. Am I okay to share this, Andy, my presentation?
Yes, of course. All good. Thank you.
Yes. Fairly self-explanatory. Don't need to spend too much time on this. And this is something I'm very keen to stress. I never make an allegation of complaint unless I believe I'm right, and I never make an allegation of complaint unless I believe I have the evidence to demonstrate or prove it. That applies to this presentation. If I'm expressing an opinion or a conclusion, I'll establish that. And people often ask me, how do I get away with posting some of the stuff that I do on Twitter and various threads? And the bottom line is, everything I do and everything I say and everything I post is truth and fact, and I've got the evidence to support it. Andy can testify to that some of the evidence I obtain and people bring to me is quite extraordinary and has exposed countless things, and we've been able to sort of make some real progress on various fronts. This quote, I know Andy used a quote from earlier. This quote from Tom Clancy, I think, is particularly appropriate. That the control of information is something that the elite always does, particularly in despotic form of government. I'm not saying that we are in despotic form of government, but what Emma has highlighted today is that we have every reason to be concerned. Let's not forget that one of the reasons we're having this SLAPPS debate is that a government minister instructed his lawyers to issue a slap to Dan Needle. So information knowledge is power. If you control information, you can control people, and I don't think there's any denying that. I have a problem with the term SLAPPS. I know what it stands for and everything else, but it kind of downplays the severity and of what these things actually are. And there's been discussion tonight about what they represent to free speech and everything else, and what laws, codes, etc. there are specific to it. And I've got lots of experience with SLAPPS, and I'll come to that later. But here's what I've done and how I've fought back against SLAPPS. And one of them is the Malicious Communications Act 1988. It makes it a criminal offence for somebody to send a malicious communication, and that can be, as you see there, the second item on the bullet point, a threat. Information that is false and is known or believed to be false by the sender. Because let's face it, often when they're sending these threats or action, they know what the basis upon what they're sending it isn't true. They know that they haven't got the grounds to make the threat, much less carry it out. So under this, and I've put it to the test with Kent Police, probably one of the worst forces to try and put that to the test. But they've failed to explain to me why one of the communications or SLAPPS you'll see later doesn't qualify under this section. Because when I've been threatened and with an action, I've called their bluff, said, right, go on then, take the action. I'm not going to do this. They failed to follow through. Well, therefore, and the reason they've done it is because they knew they had no grounds to make the threat, much less carry it out. So therefore, that must be a malicious communication. The police went to extraordinary lengths not to investigate the firm involved, a large London law firm. I'll leave it there. Blackmail. This is part of the Theft Act. Now, we assume blackmail is making threats to make a financial gain by ministers, but it's not. It's also to gain for himself or another, or with intent to cause loss to another. Now, this is particularly appropriate to the SLAPPS that were issued to me by the lawyer for the Business Banking Resolution Service. Now, what he was seeking to do was to silence me regarding concerns that I'd had and that I'd made, and statements that I'd made that they'd acted unlawfully in response to a DSAR and other offences. Now, that obviously, if he makes the threat, he's doing so to basically silence me, which would have a beneficial effect on the BBRS. It would conceal some of the evidence, perhaps, that I've been trying to get them to disclose, all of which could be beneficial to the countless victims who have been deprived of proper justice and remedy by this supposedly independent service. So again, and I've asked the police, how does that not constitute blackmail? He's made threats. He knew absolutely that there was no basis for it. And obviously the ultimate effect is that they would gain and others would lose as a result of those threats. Now, the one officer said, well, it's a square peg, round hole. I don't think it is. I think it's a round peg, round hole, but the two are over opposing sides of the spectrum and no one's really putting them together. And there's a lack of guidance on it. And I think that's something that could be, but again, it's something, unless people can adequately explain to me why that doesn't constitute, a SLAPP doesn't fall under that under certain circumstances, then surely, if you can't tell me why it doesn't, then surely it must, when you read it literally. This is probably the most significant one for me. It's abuse of legal process. And I've known about this for a number of years. And, this is a really good article from the Law Society. And I know I'll be whizzing through the slides, but there'll be a video of this so you can copy and paste from it. And the slide deck will be available as well. But, as you can see here, the Law Society define it as this, but the government defines SLAPPS as an abuse of the legal process where the primary objective is to harass, intimidate, financially and psychologically exhaust one's opponent via improper means. Now, that's a serious offence. And again, it boils down to it's an abusive process to make a threat of action that you know you have no intention and no basis of carrying out. And most of these SLAPPS are. I've got half a dozen where I've been threatened, I've called their bluff, said do it, and they've not done it because they simply don't have the basis to do so. They don't, no grounds to. Therefore, it makes it an abusive process. But try taking it to the SRA. The complaint responses and issues I've had with the SRA, you know, it's astonishing. But what makes that more astonishing is that the SRA actually, this is their own words. They say that this involves the use of threat of litigation for reasons that are not connected to resolving the genuine disputes. The SRA has that as an offence. But when I've given them cast iron evidence to prove that solicitors have made the threats, I've called their bluff, and they've failed to take the action purely because they knew they had no grounds, the SRA refuses to act. Now, I mean, it's quite astonishing. And this is, again, this is also from the Solicitors Regulation Authority as well. Now, the bottom two, threats of litigation when no legal claim arises, claims of highly exaggerated adverse consequences. But what really does frustrate me most is this, and there are specific codes to it: advancing a client's interest, taking unfair advantage of an opponent or third parties, and especially where the opponent is unrepresented or vulnerable. There are specific codes for that. And yet I'm big enough and ugly enough to take care of myself and stand up to bullies. There are thousands of others that aren't, or are not in the position to maybe know that they have these rights, and they know that they can't push back, and also that they know that they can't afford any solicitor to give them advice on it. You know, so this is where the real abuse for me lies, and there's enough already in legislation and in these codes that they, you know, to hold people accountable, but nobody is. The SRA is an absolutely disgrace of an organisation. I mean, in 2015, I've got these complaint stats. They upheld 1.5% of all complaints. 10,000 plus complaints, they upheld 1.5%. I mean, there are no circumstances where any kind of objective review, you know, or impartial review can result in that few upheld complaints. And you know, it's quite astonishing. So I'm now going to give you some examples of my own experience, but please don't think this is me talking about me, right? I'm obviously going to use examples that I can testify to and prove with evidence. And I know from the hundreds of people that I'm in contact with, many of them whistleblowers, journalists, victims of financial wrongdoing, right, that what I'm speaking about here and the examples I'm using, they've also suffered the same, you know, at the hands of similar organisations, similar regulators, you know, be they a victim of financial wrongdoing, whistleblower, or a journalist. And, you know, there's something that I think Emma might be very interested at the end of this regarding threats against the journalist. So this is my first experience. This was a letter sent to me in 2015, in the months before my employment tribunal, whistleblower employment tribunal claim against Lloyds Banking Group. And they knew that I had evidence to prove my disclosures, and obviously I needed that evidence for the benefit of the tribunal. But this came to me months beforehand, and they were demanding that I turn over all of the confidential information or destroy it. And they threatened me, as you can see here. We should make you aware, however, that in the event you do not return all confidential information and or confirm that you have irretrievably deleted this on or before 30th of April 2015, the bank reserves the right to recall details of your conduct on the relevant fraud prevention databases. Such information may be accessed from the UK and other countries and used by law enforcement agencies and by us and other employers. Now, this is the key, in brackets, and potential employers. They were basically threatening me with blacklisting. You know, they had no basis whatsoever. There was nothing that I was doing that was unlawful or in breach of contract. And the law says, and and this was all evidence for disclosure for the employment tribunal. So without which I couldn't defend myself, or I couldn't bring the claim. So, and this is a key issue, because there was a reference recently that it's some of these fraud prevention databases, and Lloyds were threatening me with the CFAS fraud prevention database. They're in a position of power where they can put anything on these databases, and that can be seen and used by countless people, and that can affect you in so many ways. And yet you don't have a right to defend yourself, or you don't have a right to access that information that's on there. And this was raised in respect to the Nigel Farage case, and what else has been going on. The use of these private databases that are being, where anything could be on there, and you're not privy to it. But again, here they were threatening me. If you don't do this, we will put you on there, and therefore your future job prospects are going to be screwed because that potential employers can see it. It's astonishing. This one here, this is a particularly egregious one. This was a threat received from the law firm Moonbeaver. Now, they were representing the Grant Thornton partner, and as you can see there, they're very threatening. They give me until 4 p.m. the following day to retract what they claimed were defamatory statements in writing to us and to the other addressees of your email, and confirm to us you will not repeat them. Now, they were adamant, should you not make the retraction nor provide the confirmation by 4 p.m. on 19th of March, the very next day, then our clients reserve the right to immediately seek relief in respect of any loss or damage arising to them in connection with the defamatory statements, together with such interim relief as they deem appropriate. And they will cover their costs and everything else. So I didn't wait until the next day. I replied the same day. And I made it perfectly clear, and I pushed back. I'd not made any defamatory statements. I will not be abiding by either of your demands. And instead, you've got until 4 p.m. tomorrow to immediately initiate the legal proceedings that you threaten in your letter, or issue an apology for the unlawful threats and or misunderstanding or interpretation on your part and that of your client. And so, okay, they made specific demands of me if I didn't do it by the 4 p.m. the following day. Did they take the action? No, they didn't. They didn't take the action that was threatened. I then therefore escalated to the SRA. And for months, they maintained their position without taking the action threatened. Now, when it came to the SRA didn't uphold my complaint because they were satisfied with what Moonbeaver and the senior partner gave them in terms of an explanation. So I did a DSAR on the SRA, who refused to disclose the information. I wanted to see, well, what did they say in response? I had to force them via a law firm to actually disclose the information. And sure enough, on 5th of June, like we're talking about, 3 months after these threats, there was an email from the Moonbeaver partner dated June the 5th to the SRA, and their explanation why they didn't take action was that my email of March 18th, where I tell them where to stick their threats and to take the action, was enough for our clients to take no further action. Hang on, you made 2 specific demands of me that in my email of March 18th, I absolutely refused to abide by, and that was enough for them not to take the action threatened. Action that they threatened they would take if I didn't abide by their threats and demands. Well, how is that? And I pointed out to the SRA, the bottom thing here then, okay, so if they're saying that, why did they then for months after March 18th reserve their positions and not tell me that their client was satisfied? So she was either lying on June the 5th to the SRA, or she was lying to me for 3 months, one out of the two. But either way, they made threats of action they didn't take out because they couldn't, bottom line. And the SRA did absolutely nothing. Other examples, BBRS. Now, I did a presentation before on the BBRS issue, and there's a video for it, and Andy's going to circulate that video because I don't want to take up all the time on this. But a lawyer at the BBRS made threats against me because I had said that their DSAR response was unlawful and dishonest, and it was upheld. My complaint against them was upheld by the ICO, and then the second DSAR response that disclosed information they previously concealed and previously claimed they didn't have. So absolutely proves that the first DSAR response was dishonest and unlawful. And I published that, and I got all kinds of threats from the BBRS for making what they said were false and defamatory statements. But they weren't, they were true. And again, the SRA has found way after way after way to avoid taking action. Every time they come up with a reason for not, I provide the evidence to prove, no, he was being dishonest. He knew that that everything I was saying was truth and fact. Osborne Clark. Now, Osborne Clark's interesting because Osborne Clark was the law firm that issued the slap against Dan Needle. Now, in 2019, same Osborne Clark wrote a letter to the Financial Times and basically threatened them unless they withdrew an article that they'd published that day that featured me and evidence provided by me. And they made false claims. Now, the article mentioned that police had launched a criminal investigation into what I had referred to them. Osborne Clark absolutely denied that this had been the case and therefore demanded it got taken down and almost cost the young journalist at the FT his job. Now, the FT bowed down to the pressure. I mean, I gave them the emails to prove. I mean, I've got the emails with the Met Police proving that they opened a criminal investigation, and then when it was resolved, proving that they actually said, right, we've wound down. It's no longer a criminal investigation because the issues have all been resolved. But the fact is, there was a criminal investigation. Now, the effect of that nearly cost that journalist his job, and it was lies by Osborne Clarke. And I stand by that. And if they're listening, or if they ever get to listen to this, they know full well that what I'm saying is truth and fact. But the fact is that since then as well, the FT has been wary of engaging with me or running stories that involve me or involve my evidence. And it's not just them. There are multiple journalists that have confirmed to me that they've been threatened if they run a story that I've given them the evidence to produce. And one large paper, even when they refused to back down, they then conceded to the FCA that they would remove all mention of me from the article. They still ran the article, but they removed all mention of me. And again, is that to just deprive me of any kind of publicity or credibility? I don't know, but that was one of the terms. They would back down if they removed all mention of me from the article. I mean, that is just, for me, it's just unwarranted pressure. The FCA, now the FCA has made threats against me before about removing stuff I've posted on social media. Again, I've said, well, that's truth and fact. You can't, you cannot force me to take down that which is true. And this is an interesting one. A Lloyds Banking Group press officer. Now, and this will come very much to what Emma was saying about threats against the press and everything else. Now, anyone who knows how press officers work in relation to the media, they do on the record, and then they do what's called background. That is understood between the journalist and the press office to be off the record. You're not allowed to share this with anybody. Well, thankfully, this particular journalist, I say thankfully, he only shared it with me because he actually lost his job over this particular issue. But he shared this stuff with me. So this is an email sent by the press officer of Lloyds Banking Group to this journalist in May of last year. Now, as you can see, there's the on the record statement. Now, the press officer makes a series of false and misleading representations in here. He makes references to the tribunal claim that I had in 2015 that aren't true. He makes references to the judgment that he's quoted completely out of context. But what's most disturbing is the background stuff. This is the stuff that you are not to share with anybody. Now, I'm going to start at the bottom first. Notice what he's written at the bottom. To publish that the FCA is investigating Lloyds without corroboration by the FCA that this is indeed the case would be an allegation that the group would take extremely seriously, particularly as we have no reason to believe any such investigation has been launched. Now, the threat there is clear, right? I mean, it doesn't say we're going to take action, but the threat is there. We will take that very seriously. But that can only mean one thing: they're going to litigate. Now, what he goes on to say here, the allegation reviewed at the time were found to be unsubstantiated. No, it wasn't. What happened at the time was that the report had the findings were falsified. And again, and I'm going to just come on to the next part because it's relevant. He says, we do not believe the individual has any ability to commence litigation. This relates to matters concluded more than 6 years ago by the Employment Tribunal, and he was not the party who suffered the alleged loss. He has no ability to bring litigation regarding the alleged trade. Well, I wasn't, because I stood up and prevented Tesco's from being defrauded of between 25 and 1.2 million on 1st of July 2014. And but for my actions, Lloyds would have got away with it. Now, he says that there's no ability to commence litigation. Now, typically that would be true. However, last year, in June of last year, I obtained a substantial cache of internal FCA documents that had been previously and unlawfully withheld from me by the FCA. The complaint, I submitted a DSAR to the Complaint Commissioner. They disclosed it, and lo and behold, there's over 200. There's 600 documents total, 200 of which were concealed from me. Now, the Complaint Commissioner disclosed them because they're all my personal information. So therefore, they have to be disclosed in response to a DSAR. But all 200 that were concealed from me all constitute my personal information, and all of them confirm or expose significant false and dishonest representations that the FCA had made in 2015 and conduct of theirs in 2015 and 2016, all of which went to not only fail to protect me as a whistleblower, they actually went out their way to compound the detriment of my employer. And in 2016, when I raised the complaint and somebody finally did investigate the FCA, the expert in October 2016 actually corroborated everything I'd said. They'd done an investigation, corroborated everything I said, and it was sent to Andrew Bailey's office. Now, they've got a big problem, because here I'd alleged a year earlier, and this was the complaint response, that there was this attempt to defraud Tesco. I prevented it, and they failed to investigate. Now that this investigation took place a year after my tribunal, the investigator of the FCA corroborated everything. Said yes, but for Mr. Carlier's actions on the day, Tesco's would have been subject to a fraud and loss by the sales desk for the gain of the LBG proprietary book, i.e. the trading book. So they corroborated everything. The complaints investigator who was investigating my complaint included that report, that investigation, that report, and that finding in the first draft of their complaint response. However, after it gets sent to Andrew Bailey's office, a month later, the same investigator completely removes all reference to that investigation, that report, and that finding, and replaces it with a conclusion that entirely contradicts it. And that's what they sent to me in December 2016. And only last year did I get a copy of this report, which just proves that, you know, the FCA lied and didn't investigate in 2015. And had they done so in 2015 and published that finding, Lloyds would have had to have settled with me for somewhere between £1 and £7 million, because that's the damage we were talking about. Now, this press officer says here that, you know, I have no basis to bring any litigation. Well, I'm pretty sure Lloyds thought that as well. However, on the 17th of August this year, the Employment Tribunal accepted my new claim based upon all of the new evidence that I obtained last year. And this is 8 years after I left Lloyds, 8 years after my original Employment Tribunal. Everyone says, oh, you're time barred and everything else. Well, I'm not time barred, because if you eventually do obtain the information that's been concealed from you, there's no time barring. And I only got that last year. I put complaints into the FCA about it. I put complaints into Lloyds about it. And Lloyds still haven't responded to the complaint I put in. Hence, I launched the Employment Tribunal claim. And please note on there that the respondent, Lloyds, has 28 days to respond to the claim. That was last Thursday. No response at all. They literally haven't responded. But there's a case management hearing on the 13th of October, because I've been given leave by the tribunal judge to make an application to have the FCA and the PRA added as second, third respondents because of their conduct and what they, you know, the detriment they caused me back in 2015. So that journal, I'm going to go back to that previous slide though, because this journalist lost their job over this, because if you note on this part here, the allegation reviewed, the FCA is not investigating. Now, literally 24 hours later, the FCA press office contact this journalist, and they tell the journalist, they corroborate what this Lloyds press officer said, yes, there is no investigation by the FCA into this, and similarly pressured him, and we would you know, take it very seriously if you claimed otherwise. Well, I showed the journalist the email from the FCA dated 6th of March, you know, which is 2 months before this, where they accept my complaint and confirm that they are now conducting a thorough investigation into this. Now, after this happened, and after the journalist told me that this FCA press officer had effectively colluded with the Lloyds press officer to cover his arse and basically corroborate what he was saying, you know, the false representations he was saying, I made a complaint to the FCA. How did the FCA respond? Well, it's over a year now. They've still not responded to the complaint, and I've put everything in there. What the FCA then did a month later is then reverse their decision to investigate the allegations and the fraud against myself and Tesco. So they literally reversed the decision to investigate so as to protect their press officer who had made false representations and to protect the Lloyds press officer. So, and this journalist, the bottom line is he lost, fortunately he's got a job, he's got another job, but he lost his job because he was trying to write an article on this. And the FCA press office and the Lloyds press office lied to him, took it up with his employer and kicked up at such a stink, and he was made redundant. So again, it speaks to what Emma was saying earlier about the freedom of the press, and it's astonishing. Am I surprised Lloyds would do it? No, normally, you know, you expect the people that are most exposed to be, you know, if they're in a cornered rat is a cornered rat no matter who they are. But for the FCA to get involved in this and try and corroborate and conceal the fraud against me and Tesco, the two separate frauds, the fraud against them and then the fraud against me, by the way, the falsified investigation into it, astonishing. So, but, you know, and I hope this is shone a light. And it's not just about me. Andy knows I'm in contact with tons of whistleblowers, all of whom are subject to the same kind of treatment by their employer in the FCA, and also have enormous difficulty in getting their stories into the press. 6 other journalists have told me that they've had similar threats. They don't want to share the information, and I don't blame them. I wouldn't, because speaking up, really, it should be protected. But unfortunately, today, whether you're a whistleblower or you're a journalist, speaking up can be an all or nothing gamble. And I'll leave it there.
Paul, thank you very much indeed. Thank you very, very much indeed. Can we take a moment just to show our appreciation to Paul and all the other speakers for what they've contributed in this very, very interesting conversation we've had today. Paul, thank you very, very much indeed. And that leaves us 5 or 10 minutes or so to deal with any final comments or questions before we wrap things up. I will be going around to the previous speakers who are still here just for any final comments they'd like to make. I'll go to Roger, then I'll go to Joanna if she's still with us. But does anybody else want to come in with anything before we do that? Eric Smith, lovely to see you, Eric. You've been quiet tonight. Nice to have you with us. Eric, please take a moment to very briefly tell everybody a little bit about yourself and where you are, and then share your thoughts about SLAPPS tonight. Thank you.
Hi, everyone. It's a pleasure being with you, and found the presentation extremely interesting. I had a company that's created a decision assistance technology that enables users to score and rank mutual funds and ETFs. We're introducing it to individual investors that will have a disruptive effect on the financial services marketplace, the product-oriented product sales, conflict of interest-ridden financial services marketplace in the U.S. And as Andy knows, I experienced something equivalent to this years ago, to keep what we're now being able to introduce to try to prevent it from hitting the market. So I'm very sensitive to the issues. It's not just in the UK and the EU. This is going on in the US, and I have some personal experience with enduring all of that. So that's it, Andy. That's all I wanted to say. It's a US problem as well.
Eric, thank you very much indeed. Clearly the suppression of truth and fact is a global issue right now. Joanna's just had to jump off, so we won't be able to go to Joanna for her final thoughts. Before we go to Roger for his final thoughts, I'll just check in. Does anybody else want to come in on something before we go to Roger? I think we're going to go to Roger. Okay. My goodness me, it looks like I'm running a meeting that's actually going to end on time for a change, and it really is a change. Roger Mullin, please do share any final thoughts that you'd like to make. Thank you.
Yes, you're definitely going to finish in time, because I've got very little to add other than to say I think it's been very useful bringing together people to begin to discuss this issue. There's obviously a lot more work needs to be done, not least in defining SLAPPS and being clear about what kind of reforms are needed. And so my hope would be that this is the beginning rather than a one-off exercise in trying to inform and engage members of TTF in particular about the need to reform SLAPPS. And I'll just thank you for the invite, Andy, and leave it there.
Roger, thank you very much indeed. And I'll try to join you in the conversation with Lord Strathcarron and Joanna Cherry. Perhaps TTF can have some ongoing involvement. Exactly as you say, today's event shouldn't be a one-off. It should be the beginning of an ongoing process of dialogue. And on that note, I'd like to thank you all very, very much indeed for setting aside some time this evening for today's conversation about SLAPPS. It really is a remarkably important topic. Hearing Paul talk about the lived experience that he's had really does drive it home just how problematic this area is, and frankly, how we need to stand up against it and fight against it. Thank you all very much indeed. Enjoy the rest of your day and the rest of the evening. Thank you very much, folks. Thank you. Bye-bye. Bye-bye. Thanks, Roger. Thank you. Bye-bye.